Hey, Harry.
Chris?
As we're waiting for a couple more people to get on, a couple things I would like to just bring up. We'd like to thank a handful of our sponsors that we have. We have M.W. Gary, who is our virtual lunch sponsor. We appreciate their support and helping us offset the cost of the online services to do this. CLS, Contract Land Staff, is also one of our sponsors. And the host of the Crypto Energy Summit, which is going to be May 26th at the Rivers Casino. It's Tom Smouse and TVS Oil and Gas Title Services, our sponsors this year. We really appreciate them supporting the chapter and helping us keep things rolling. And then we also appreciate the individual donations that we get. Marilyn just graciously gave us some money to help continue what we're doing here in the Three Rivers chapter. Kudos to Michelle Freeman from CLS. We appreciate her support. As we get a couple more people on, also would like to remind everybody some upcoming events. Next Tuesday, we're having our quarterly board meeting for the chapter. So if you would like to be invited to that, let me know. That's open up to everybody. Also, in May 13th and 14th is the Region 5 Spring Forum. It's going to be in Louisville, Kentucky. That's a Friday and Saturday. The Saturday session will be very tight as they're planning to go to Churchill Downs for the afternoon. So sometimes region forums get a little long on Saturday. This one will not. And then also don't forget that June 5th to the 8th in Cleveland this year, Chapter 13 will be hosting the International Conference. So we're looking forward to that as well. And I know they're looking for volunteers for that. So if you're interested in attending or you'd like to volunteer, either reach out to myself or somebody from Chapter 13 and I can put you in touch with them. And just one more thing, in the event that either you're looking for work or you're looking to hire people, please reach out to me. It's been a great conduit to be able to put the people in touch with the right people. And I think we've trying to get everybody working and stayed working and getting quality people through our efforts and through the education of the IRWA. So at this time, I'm going to turn everything over to David. David, if you'd like to introduce yourself and just remind everybody to please mute your mic. David, do you want questions asked during your presentation? Or do you want people to wait till the end?
Well, I think it's just a matter of time. So if you, it'll take about 30-40 minutes to get through the presentation. So if we're limited on time, we can certainly hold the questions off to the end.
Okay.
It's up to you if you want to, you feel that there is a question, we can interrupt the presentation so that the individual doesn't lose their train of thought on that. So
okay,
I'm flexible.
All righty. Well, I'm going to turn this over to you at this time. And if you don't have your mic muted, please do so at this time. And it's all yours, David. Okay.
Thank you, Johnny. Well, I just want to thank Johnny for inviting me to speak today to your chapter. I was connected with Johnny through the International Transportation Committee, which I am at large member of. A little background on myself. I work for Tierra Right of Way. We're associated with CLS. We were merged about a couple of years ago. So now we're part of the family of companies of CLS. And I have a bachelor's degree from the University of Arizona. Go Wildcats. I had to put that in, sorry. But I have a bachelor's in environmental science, and I have a master's and a doctorate from the University of Phoenix. I started my career in the construction management and engineering industry, working for the transportation department here in Arizona, worked as a construction project manager. And then I moved on to working for a few engineering firms where we worked on planning and development projects. But majority of my career has been with the City of Tucson as administrator, where I was overseeing all the environmental programs for the city, the permitting, the reporting requirements. Part of that was required me to be a technical advisor to our real estate division, who worked on all our road improvement projects and the property acquisitions. So that's how I kind of got into this industry on the client side, where I would get involved with throughout the planning, engineering, and construction phases of a road improvement project. And now I've retired from the city and have been working with Tierra now for about 4 years. So now I'm on the consultant side of things. So I have a unique perspective on both from the client and the consultant side. So it gives me a little bit more information to share, where I can kind of connect the dots, which I hope I'll be able to share with you today, and how all the right-of-way agents here today can become the conduit of information that you can share with your clients, especially when it comes to environmental due diligence, which is going to be our topic. So what I'm going to do is here get started with sharing my screen. So I have, Johnny, it says I've disabled the participant screening sharing, so I can't share here on my end. Let's see here. I'm going to try to. Are you able to see this?
Let me find the setting for that.
Okay.
How about now?
Yeah, you guys tell me if you can, let me see here. Okay, we got it. Okay, can everyone see this?
Yeah.
Okay, good.
If you go up to your right-hand corner and hit share, David, I think it'll get through it'll take the slides bigger where the red button is.
Oh, got you. That's not what I want. Oh.
That'll work. We'll just go with that.
I think if you just go over to where it says from beginning, over very, very end, top left, you see on your taskbar, go over where it says from beginning and click on there. That should work.
Yeah, I haven't opened it. That's where I was gonna.
There we go.
Everyone see that now, right?
Thank you, Gordon.
Okay. So again, this is going to be a topic that I know, Johnny, Tony, some of you are in the oil and gas industry. Hopefully this will help you get a better understanding within the right-of-way industry, how environmental due diligence.
Or if you have checked your status online, there is a tracking number provided, and it's been.
Okay. So this will help you kind of link the importance of environmental site assessments, which we'll be talking of phase one, mostly about today, and how you can take that information and hopefully as a negotiating tool to leverage the valuation of a property, or understand more what the prospective purchaser liability is associated with acquiring that property. So these are the topics we're going to be covering today. All appropriate inquiry rule, that is the EPA rule. That's the umbrella rule for how you conduct a phase one, otherwise known as AAI rule. We're going to get into the due diligence process and what a phase one and phase two environmental site assessment, or ESA, is. And then the recs associated with those reports, which are referred to as recognized environmental conditions. That's a common term you'll see in those phase one reports. And then how it affects the prospective purchaser and liability protection. And then we'll get into pre-construction planning, pre-demolition, and asbestos and lead. So who is affected by the AAI inquiry? Under EPA definition, all appropriate inquiry requirements are applicable to any party who may potentially claim protection from CERCLA or Superfund, as it referred to commonly. Protection from CERCLA liability as an innocent landowner, a bona fide prospective purchaser, or a contiguous property owner. And these are three different categories that we'll get into here later in the presentation. So all appropriate inquiry, why is it important? Well, these are the key benefits you get from doing your due diligence, is it provides owner protection from liability, cleanup, and regulatory oversight. It identifies the RECs, or recognized environmental conditions, early in the planning process. It avoids costly project delays and potential lawsuits. And I'll explain a little bit how there is a little bit of a misconception, I guess, from the planning and engineering sectors, that environmental typically carries this black cloud over the project, and it just sucks all the project costs or the budget from dealing with these unknowns. And I'll explain a little bit how that's quite the opposite. And it reduces project costs and minimizes potential health and safety risks during construction. And this is key because a lot of times you can get through all the check boxes and saying you've got everything out of the way, you've got your environmental clearance, you're ready for construction. As soon as you get a bucket in the ground and you start excavating, you find something, and all of a sudden there's everything comes to a stop, and now we have to deal with an unknown environmental condition that was not identified. So it's real important when it comes to safety, OSHA safety related, the risks associated to the workers and contractors, as well as environmental oversight, regulatory agencies that have another concern about construction when it's related to, especially in older areas that are been developed for quite some time in industrial commercial type properties. So an all appropriate inquiry, this is real key to remember. It's probably the most important slide in the whole presentation. If you can take away anything, this is what I would like you to remember. So all appropriate inquiries must be conducted or updated within 1 year prior to the date of property acquisition. If all appropriate inquiries are conducted more than 180 days prior to the acquisition date, certain aspects of the inquiries must be updated. So what does this mean? Essentially, your phase one has a shelf life of 6 months or 180 days. And so if you can plan to request, whether it's you or the client that handles this, having the environmental firm to start doing their due diligence and conducting the phase one. The phase one starts, the actual date starts the moment they start going to doing some database searches, gathering information that's going to be provided in the report. That is the 6 month, that's when it starts. And you would want to make sure that you're closing escrow prior to that 6 month expiry. Here's the reason why that's important. If you don't, you lose all your owner liability protections associated with the AAI rule. So if you say our negotiations are kind of going on beyond the 6 month, there's a simple way to kind of get that phase one current is by doing an update. And typically that just requires your environmental firm to go and do another database search and get all the records that are available through the municipalities, states, and federal regulatory agencies. And they make sure that all the information is up to date as much as possible, because things can change over time with land ownership, as you know, and more information can be posted in some of these websites that obviously are not always current to the day that you did your search. So that is helpful to get new information in that report. The costs associated with that, typically, it's not much. It's not like getting a whole new phase one done. It depends on the contractor, but typically it takes very little effort, can be done within a week or two, and it can amend the phase one. Now, if you go on beyond the year, again, you're now outside of that 6-month window, but now has passed a year, you will need to have a whole new phase one done, which will be a little bit more costly. So if you're ordering phase ones or whoever is doing that in the project, it's good to know that they can kind of plan this out and see if we can get the phase one within the closing date 6-month window. That's going to provide you the owner liability protection provided under the EPA AAI rule. This is a very important thing to remember. Most reports have a date on it, the cover date. Sometimes the date is misleading. If the consultant puts a date it was completed, that does not give you the AAI 6-month date. So what I've done in the past is ask the environmental firm could put the AAI date, so that way you can track that much easier. If you go back into your files and dig up the phase one report and you see that it's coming close to expiring, you can catch it before closing of that land transaction. So due diligence, why is it necessary? This is why. In order for a prospective land purchaser to obtain owner liability protection under circle law, the due diligence serves to confirm all material facts in regard to a property transaction. In other words, that report pretty much has all the facts they've been able to gather regarding that property. And it goes back through, a lot of times it includes a title search, because you want to capture all the different deeds that potentially could have some deed restrictions in it. A lot of times environmental firms are not asked to do that because it's not included in their scope of work, but that could be done separately or included in their scope. But it's important that you capture all the previous ownership of that property so you get a better history of how that land was used and who owned it at a given time. In the event you have to go back to a previous property owner to understand more what really happened in this on this piece of property, that there's no evidence of what that business or whatever it is that was taking place on that property. So what's the difference between an EIS and ESA? This is a common thing where we are in this world of acronyms, and a lot of times we confuse what these two terms are. So essentially, an environmental impact statement, or EIS, is follows under the NEPA umbrella law. It considers all relevant environmental requirements. This means it includes air quality, water quality, wastewater, soils, aquatic life, vegetation. It captures everything in this EIS. It establishes a process for coordinating with environmental regulatory agencies. And it can take up to 2 years to complete an EIS. And this is a key thing, it involves public input. So what is an environmental site assessment for a phase one ESA? It's essentially a report for a real estate transaction. It identifies potential and existing environmental contamination and or associated liabilities. And it addresses underlying land issues and physical improvements. And I'll get a little bit more into that later in the presentation. It can take typically from 30 to 60 days to complete a phase one, and it requires no public input. So who is affected? The all appropriate inquiry requirements are applicable to any party who may potentially claim protection under the circle liability as an innocent landowner, a bona fide prospective purchaser, or a contiguous property owner. And this is going to be key to understand the subtle differences between those three categories of property ownership. I've got a link here to go to a real good video that gives you an overview, 5-minute overview of how a phase one is conducted. I won't go through that now because I've had some problems in getting this link to really pop up. But you'll have access to this presentation, so feel free to look at that link. It'll give you a little bit more information how phase one is actually done. So prospective purchaser definition is a party claiming to be a bona fide prospective purchaser, contiguous property owner, or Section 101(35)AI innocent landowner bears the burden of proving that it meets the conditions of the applicable landowner liability protection. So what is section 10135AI? Why is that important? Well, this is a situation where the landowner can still be an innocent landowner and get the owner liability protection when you have knowledge of contamination from that property. Say, for example, it's an old gas station and the building no longer is there, but there are some underground storage tanks still underneath the surface of the ground. You know that that is the case. You still purchased the property, but you did your phase one. It's with the 6-month window that you close escrow, so you still retain those owner liability protection rights. But under that, you must ensure contaminated area is contained. And this is where we get into a little bit more owner responsibilities as the landowner, that if you're going to retain that owner liability protection, you have to ensure that that existing contamination does not spread, or you do not add any more to what the existing condition is. That's real key to know. So to meet the statutory criteria of a bona fide prospective purchaser or contiguous property owner or innocent landowner, a person must perform the all appropriate inquiry or phase one into the previous ownership and uses of property before acquisition of the property. Again, this is to emphasize that you have to make sure you close on that land property before the 6 months expires, so you can retain the owner liability protections. So purchasers that purchase a property and then do a phase one after they have closed on escrow and now own the property will not get that protection. They have no longer be able to retain any property rights or owner liability rights as an innocent landowner because they did not do the phase one prior to closing escrow. But I'm going to get a little bit into how you can still get some protection. You can provide advice to your clients on how you can still at least minimize costs for something that say that is unknown in the project timeline is kind of pushing this. We have to get this property acquired. We're pushing back the project. So there's a lot of things to consider, and I'll talk a little bit how you can still get some protection even though you have purchased the property before the or after the phase one has expired. So these are the three protected classes: the innocent landowner, bona fide prospective purchaser, and the contiguous property owner. So what is an innocent landowner? Essentially, it's someone who does the phase one. You have no knowledge or reason to believe that the hazardous substance release occurred on that property. And essentially the phase one will tell you that there are no recognized environmental conditions associated with that property. And you have no relationship with third party that caused a release. Now that could be with that specific property, or it could be an adjacent property where you have underlying condition that might impact your property because of what was adjacent to your property. Say there was a gas station next door and you bought the adjacent parcel. Now we have contamination that's kind of gone underneath, below the subsurface, and has traveled across underneath the property that you're acquiring. So a bona fide prospective purchaser, what is that? That is someone who does the AEI. They have knowledge of contamination and they purchase property after hazardous substance disposal has ceased. For example, we have a gas station again, or dry cleaners is another example. That business has ceased. They no longer are operating as a gas station or dry cleaners, but there's an existing condition beneath that, underneath that property. So essentially, there are some conditions that will have to be inherited by the new property owner. There's a responsibility to either minimize the spread of that existing contamination, or you may have to be forced to clean it up. And that's why it's important to understand all these conditions prior to the acquisition, because the risk might not be worth purchasing the property And you can avoid that by maybe just tweaking the alignment of the road. If we can tweak it a little up like 30, 40 feet to the north or whatever, to avoid the property that is a big concern. Sometimes that's why it's good to get involved in the planning process and with the engineers as they do the design. Those things sometimes can be worked out. Not always, but that is a way to kind of avoid a possible mini pit that for a property that you don't want to acquire. So what are some fulfilling continuing obligations as a property owner who knows that there is some form of contamination associated with that property? Well, there's some institutional controls. And essentially institutional controls are non-engineered instruments such as administrative and legal controls that help minimize the potential for human exposure to contamination. That is essentially what an institutional control, and I'll get a little bit into an example of what that is here later in the presentation. Deed restrictions. A lot of times there's deed restrictions in the deed or environmental liens that actually specify that there is certain land uses that the property cannot be used for. For example, maybe there is an old gas station there, everything is intact, there's no contamination. They decide to abandon the tank in place. There's no evidence of contamination or even leaving the property. But say the owner wants to build a daycare center. Well, that will say that in the deed that that property cannot be used for a daycare center. So those are the types of things you'll see in the deed if there is a deed restriction. Also, it must meet the 180-day shelf life of escrow closing. Again, this applies to all three of these categories of land ownership. So what is a contiguous property owner? Again, you do the AAI phase 1. You're not associated with a release or third party causing it. You take reasonable steps to address the release. For example, say you know there's an underground storage tank. You want to mitigate that, get that removed, cleaned it up, and you've now got environmental clearance. And then you report a release to a local regulatory agency if it has been identified as a potential source. And there are cases where I've been involved. We purchased properties and we have identified such a large environmental impact to the soil beneath and potentially groundwater that once you do the phase 2, which involves typically physical sampling of soil and maybe even groundwater if it's shallow enough, and you get evidence that the concentrations of whatever the contaminant is in that soil is so high that it triggers a cleanup action. When that happens, that phase 1 and phase 2 must be provided to a regulatory agency such as the local city, county, or state, whoever oversees that, so that they can identify who the responsible party is and what cleanup actions required. So that's why it's important to know the full extent of what that contamination, if there is that type of situation, and do you want to take on that responsibility and liability associated with that, and also the costs associated with the cleanup. So to obtain liability protection, again, you must conduct the AAI prior to purchase, and you must meet continuing obligations, complying with the land restrictions, not impeding institutional controls, taking reasonable steps to prevent the release, and cooperating with federal and state agencies. So these are some of the environmental impacts that are underlying issues that you can come across. Typically, you'll find these in more heavily populated areas where you have a lot of businesses, especially older parts of cities and towns that have had a history of different businesses and land ownership has changed. You can have a railroad going across. You can have a lot of things going on in more heavily developed areas versus more in the rural areas. But you can come across groundwater plume, soil vapor intrusion. That is a fairly, not a new term, but it's been out there probably for the last 15, 20 years. EPA is pushing this. When you do a phase 1, you'll see this term come up when you have an adjacent parcel, for example, and again, an underground storage tank, a gasoline station that still has a tank, but potentially the vapor could travel adjacent underneath and impact whatever development that you would have on your property. So for example, here in Arizona, we don't have many basements in a lot of our buildings. But say back in the Midwest and East, where you do have basements are common, you have vapor transporter. It's similar to radon. It will travel the least path of resistance, and you can have these vapors accumulate in basements where it can gather up and increase in concentration and become a hazard to whoever is working or living in that structure. So that's why vapor intrusion can be important depending on what the adjacent land use is and whether there's any reason to think that a vapor intrusion survey needs to be conducted. Subsurface soil contamination, that could be from different types of things over the land use. Again, this is where it's important to have a title search done so you understand the types of businesses that have used that property, so you can get a better idea of whether there was anything that's suspicious that could be potentially impacting the value of the property, or if there's any underlying contamination. And then there's elevated metals. A lot of this is very common throughout the country. Here in Arizona, we have, because we have mining such a big industry, we have a high concentration of lead and arsenic in our soils. Now this can trigger a couple things. The regulatory agencies don't typically care whether our underlying the background concentration levels are in the soil, because if you're disturbing the soil, now you've kind of triggered this process where you have to do more investigation, and depending on the land use, or if you have more importantly, if you have a groundwater well on the property, now this is important. So these are things to just kind of understand a little bit, but typically, those are things you can work around that don't really have a big impact on the property, because again, if they're naturally occurring and you understand what the full extent of your project is, the vertical and horizontal extent, then you can kind of understand whether this is an issue or not to worry about. And then PCBs are from old transformers. Typically, PCBs were where they leaked, and you have transformer pads either on the ground or mounted on a pole. Those leaked over time. Those types of contaminants stay in the soil, and they don't get easily moved through runoff. They like to attach to soil. They bond to soil very tightly. So typically this type of contamination doesn't travel very far. It stays shallow in the ground. But those are things, as you do a phase one and even as you do a walk around the property, those are things to recognize, obviously, or recognize in the report if it's identified. So here's a great map to just give you some idea of how a plume can impact so much property in a highly populated or highly developed area. This map, again, this is a map I came up with a previous presentation. It was for state of Missouri. But this map essentially shows you this lighter shaded area is considered a plume boundary. In other words, groundwater has been contaminated beneath the soil surface. And you can see the aerial extent of this. You can see all these streets, and who knows how many properties this underlies, how that is impacting already a very large area. Now, if you look at the darker shaded area here in the middle, that is the higher concentration. Typically, that is really where you have much more contamination in the groundwater soil. And that's the smaller plume boundary we have here. Now, all these little markers, believe it or not, are either monitoring wells, compliance wells, extraction wells, injection wells, you name it. They have fully assessed the extent of this plume by putting these wells in to understand the vertical and horizontal extent of the contamination. Now, these wells are obviously on somebody's property. And if you come along and your road comes through an area where you have this that cuts through an area where there's a well possibly on the property. Now you have to deal with easements, because most likely if it's an active cleanup site, you will not be able to abandon that well. And as a new property owner, you have to consider what easements are required and how that'll affect the valuation of the property. Now, these out here that you see, this is much more rural, believe it or not. These are all private drinking water wells. So you can imagine if your project was going through any of this area, say a main highway or something, now you're looking at private well rights, which are totally different animal in its own, because most state agencies will not regulate private wells. So those are things to consider on a project corridor as it comes through an area, especially in more heavy industrial commercial areas. These are things that you'll need to take note of. Now, this is, I pulled this map up. This is a neat map that shows the oil and gas wells throughout the state of Pennsylvania. Now, these are clusters. I can only imagine how many wells are in these, but because there's so many concentrated in these areas, again, this just gives you kind of an idea of how you have to understand well ownership and property rights, and how that will sometimes get pulled into the negotiations of acquiring a property. But this is typical that you can run into in some areas where they are, you have to understand where these wells are first. And the phase one typically will share that information. They'll have a map and they'll describe whether there's something there that you have to do some further investigation on. So I'm going to give you a little bit of hydrology 101 here, how this all, because it's hard for us to envision really what's going on beneath the surface of the ground. So this is just a simple cartoon of a cross section of the soil. Here you have the surface. This dashed line on the surface is your plume boundary on the surface. And so you have this smaller area over off to the left is the area of release. This is wherever the release was, if it was a gas station or dry cleaners or whatever it was, somehow traveled down gradient and it got into either a tributary, a wash or drainage or whatever it is, and somehow was able to work its way down into the several layers of soil and ultimately groundwater. Now, these blue layers represent different depths of groundwater. And then the area that's kind of tan or brownish colors above it, what they referred to as the Beto zone is the unsaturated zone. And anything beneath that is called the saturated zone, where you can have some form of groundwater in the soil. But this is kind of a highway that cuts across the plume. Say you have a project corridor that goes along this highway 100. Now you got to acquire properties that go along this. And now you have to understand, is there really a direct impact to property value and liability associated with acquiring that property? And so it's good to understand how all these kind of are connected, and it helps you to at least make some decisions as you go forward in the planning process where the property is going to be acquired, or maybe you have to redesign to avoid purchasing a property that could be a huge impact to the budget. Now, this is a good example of downtown Tucson. I use this a lot because you can kind of see from an aerial map, this is downtown. You can see the railroad coming right through. There's an old railroad depot. These three different colored shapes are three different groundwater plumes from diesel contamination. There's essentially 4 to 5 feet of diesel fuel, about 50 to 75 feet down, that is floating on top of groundwater. They had old diesel fuel line that came from California, all the way from the West Coast, and it went to a fuel farm that was further off the map where they stored diesel fuel. It has been abandoned in place, but over time it leaked and eventually it impacted the soil and the groundwater. So I'll show you what happens when this is just kind of give you kind of a one-time snapshot of what is going on beneath the surface of the soil. But now we have a road improvement project that's cutting right through all this. And this blue area you see is the new road improvement that the city is planning to, well, they've started construction now. And you can see all these smaller dots and smaller markers are all monitoring wells that had to be dealt with when they acquired the property for the right of way. So these are some of the things to kind of help you understand that you have to sometimes look out of the box and look at the phase one, kind of ask questions to help you understand really what are the impacts of the property value, the liability, or the long-term effects. If say, I always tell people the phase one will capture 99% of the information you need in order to feel comfortable that you can purchase the property. But it's the 1% that can come back and bite you. And sometimes that 1% doesn't start showing up until you start getting a shovel in the ground and you start tearing up the soil or demoing a building. And then you identify other things that you just weren't able to find in a record, public record through your database search. This is a common thing. The environmental firm will do a site reconnaissance and look through the property. This was a body paint shop. The owner no longer was there. They left this mess behind. So obviously this is a cost to the client or the current property owner, and that's where you negotiate. If the current property owner is willing to take on the cost to clean this up, or use this as a negotiating tool, saying you estimate what this would cost, and you can decrease the value of the property if the new owner is willing to handle the cleanup. So those are things that is good to be aware of as you get into negotiations for some of the right of way. Again, this is a typical thing you see in a maintenance shop. This is a floor drain, and we have no idea what this liquid is. It could be water, or it could be a contaminated chemical. It gets into a pipe underneath the slab and it travels, and now the soil beneath it could be impacted. But a phase two would help identify if there's any impact beneath the slab. They would do some coring through the concrete beneath and get some soil samples and then pull that up and see if there's any concern with the results. They can determine whether there is a problem or not. So subtle differences between an EIS, again, and an ESA. Again, EIS falls under the NEPA. It's a purpose and proposed action. Usually it's for a huge highway, federal or highway project. They list significant issues that will be impacted and have an alternative development. A lot of times the corridor project needs to be adjusted to avoid any impacts to wildlife or vegetation if it's considered endangered species, things like that. You have to understand the environmental consequences, and it could take 18 to 24 months to complete the EIS. It requires public input. And again, it covers every aspect of environmental issues that you can imagine. This is a report they typically refer to as the Bugs and Bunny report, because it's so encompassing of so many things they have to include in their assessment. Now, for environmental science assessment, it falls under the CERCO or Superfund law. You do an historical land use, you search for historical land use. You can do a 50-year title search, or you can go all the way back to when it was first undeveloped. Typically, you can ask your environmental firm to do the title search, but only do a search for environmental liens or deed restrictions. So it lessens the time and the cost if you can tailor it to those two specific things, and they will be able to capture all the information you need that would be relevant to the phase one report. They do a search in public records. They go through state, county, city, federal databases. They do title land use restrictions. Again, it could be in the deed if there is any restrictions. It takes typically 30 to 60 days, and they do a visual inspection of the property as part of that process. And sometimes they will go out and interview tenants of the property if it's an active business to see if there's any more information they can gather, or adjacent property owners as well. If there's any permits with that, it'll be included in that phase one. You get nice aerial maps typically to review, so you get some understanding of land uses from a aerial perspective, and the project, how it intersects with the property you're looking at to acquire. Again, you interview tenants and neighbors, and then you inspect the buildings for asbestos and lead. A lot of times that's required to be abated before you can actually do the demo work on the building to clear right away. I usually show this, I'm not going to go through this, but this is a good decision flow chart that helps you understand the 3 different phases: the planning phase of a project development, and then you get into environmental phase, and then you get into design phase. And it kind of gives you an idea of the flow of decision-making and tasks that have to happen. This, of course, is going to involve several people: planners, engineers, right-of-way agents, contractors, the clients, and other group of people sometimes that are involved with these projects at the beginning. And this is just kind of helps you kind of figure out how the flow of the project should proceed as you get through the planning and environmental and design phases. Okay, so we talked about institutional control before. This is an example of one that it's a former tungsten site. This is about a 40-acre parcel that's on a pretty much undeveloped property. It's got this remnant building that's sitting on the property. The Parks and Rec Department that had purchased this property was looking to develop it as an urban park, not with the typical grass and ball fields and all that, but just trails and picnic benches and parking and dog and pedestrian paths, things like that. When they started doing the phase one, they identified this previous company that operated a tungsten processing site during the Second World War. And if for some of you who aren't familiar with tungsten, which was mined somewhere south of Tucson, some large mine, they would mine it for tungsten. Tungsten is a very hard alloy, and they would add it to steel to harden the steel, and they would use it in munitions and bombs in the tips of these so they could penetrate armor. So tungsten was an important thing back in the Second World War. So it was not easily it was not something you could find anywhere. So there was a lot of it coming through this processing facility. Unfortunately, back then, in the 40s and 50s, there wasn't any environmental regulations that tell you, hey, you have to contain all the hazardous waste that you have. And so much of this was just stockpiled out on the ground outside the building. And it went into this large ravine where it was basically a tributary. When it rained, it floods and it carries, everything downstream. So a lot of this just washed into the stream over the years, decades. So they did more soil sampling and identified that there was very high concentrations. They would have to do a cleanup before they could do the park development. And they estimated the cost to be a little over $1 million for the soil cleanup. So the Parks Department did not have that kind of money in their budget to address that. So now that they own the property and they are aware of the impact to the soil, they have to implement institutional control. So the fence that's surrounding what they call the hot spot, or the higher concentration, was put up to avoid any pedestrian traffic from getting into this area. So that would be considered an institutional control. Another one would be a parking lot. You have asphalt or concrete. Now you have a way to put a barrier on top of the soil where there's no runoff from rain events that could penetrate through the soil and carry that contamination further into the soil. So those are types of things that you that are considered institutional controls. Here's just a typical underground storage tank that you can encounter. You can see the tank looks somewhat, it's crusted with a soil, but these are dual walled. Typically an underground storage tank doesn't leak. Where you find the leak into the soil is all the plumbing connected to the dispenser, because at the joints where it's the weakest, typically that's where the fuel will leak, and that's where it'll get into the soil. So a lot of times it's not the actual tank cavity or the pit, but it'll be the plumbing or the piping that's connected to wherever they're dispensing the fuel. So pre-demolition, some things to consider. Obviously lead-based paint, because it falls under HUD. Those are things that, especially if the building does not need to be demoed, and say the client is expecting to repurpose the building or lease it out. And if it has any lead-based paint, they need to understand that those things need to be abated, as well as asbestos. Before any contractor that meets certain levels of asbestos containing materials, they have to remove that before the demolition or can occur on that building. Also, you have to involve the regulatory agencies and do the reporting required with that. A lot of times it involves permits, and your consultants and contracts obviously can handle all that for you, but you have to understand how all that has to play in before you can even start getting that phase one and start negotiating with the property owner before you can continue with getting into eventually closing on the property. And then abatement on pre-demolition asbestos, which are considered under NIOSH standards. So what are the advantages and disadvantages of doing environmental due diligence or phase one? An advantage is you reduce construction costs. Now, again, we talked about how a lot of times most planners and engineers think if you pull in the environmental guys, they're going to just rain on everything and say you're just trying to make money off of it. Well, if you understand how it can be really used as a useful tool for decision making through the planning and design, it will reduce costs, because you have to remember the more you know up front, the less impacts you're going to have during construction. And if you can minimize any possibility of encountering something during construction, then you're going to be ahead of the game. If you avoid doing any of this early in the planning and even during the design, you're going to be stuck with a possibility that you're going to encounter a huge problem. And now that cost is going to go much higher than all those that you spent on just doing some preliminary studies. Plus, that project is going to come to a screeching halt. And everyone knows if you stop that contractor, it's all in time and materials. That's going to only make that project cost go up through the roof. So there are some advantages for reducing construction costs if you look at it from a way that it will help you do some educated decision making throughout the process. It'll avoid liability. You know, that's what it's all about. You know, you want to minimize it. Can't take it away completely, but you can definitely minimize it. You avoid costly cleanup costs. You have no regulatory oversight. This is huge, because as soon as you have a state agency or a federal agency coming down on the property and saying, hey, we now know that you purchased this property and we need to have you clean it up. Now you've got a whole different problem to deal with, which you don't need for a project. The environmental clearance for surplus properties, it'll increase value. If you purchase properties that no, you don't need the entire parcel, but you're going to have surplus property, and say the client will later on auction off that property, you're going to be able to get top dollar because you got environmental clearance associated with that property. You're going to retain the maximum value for it. And then you're going to improve public image. That's going to be key, because any project, anyone that goes into public meetings and for a road improvement project or you name it, it's got a huge bullseye on it. And they're going to question whether the client is doing adequate enough work to ensure the health and safety to the public. So if you meet the minimum requirements, you have a good way to justify, yes, this is what we're doing. Sometimes you have to go above and beyond, because that will only improve the public image. It'll take away all those that are trying to undo the project or sabotage the project. A lot of times this will take that argument out of the picture, and now you don't have as much to deal with through all this public meeting process as they provide updates to the public on larger road improvement projects. Disadvantage, you can have regulatory oversight because you didn't do the due diligence. You have long-term liability. You have increased construction costs, project delays, unknown, and cleanup costs. That you never know. Reporting and permits, costs, legal costs, that's huge. It would only go into where possibly you would have to hire an attorney to help you mitigate on what it is that you're responsible for cleaning up. You're going to have lower property value, especially with surplus property, and you're going to get a poor public image. So this is my end of my presentation. I know I went over a little bit because there was probably a lot of information here. I didn't want to rush through it, but I wanted to at least go through where you're able to understand most of this because if you haven't seen this before, then at least now you can get a better understanding why environmental due diligence is so important. So I don't know if there's any questions, comments, but I'm open to answering any questions at this time.
Do we have any questions for David? Now, the material he did go over, if you would take the IRWA course 600 environmental awareness, you'd get more into this and better, more understanding of what David's talking about here. As I was telling him before we started the call, when I first got on a right-of-way project, I had no clue what we were talking about when we were talking about doing an environmental assessment. It's a very interesting process as a right-of-way agent. It's really great to be able to see, how you have to, adjust your LOD during construction or design to avoid some of these areas.
Johnny, it's Gordon McNair. Can I just make a comment here?
Go right ahead, Gordon.
Yeah, David, man, was I ever impressed with your presentation. I'm a instructor, the IRWA. I teach environmental courses in both Canada and the United States. And I got to tell you, my friend, you did an awesome job here today. I was very, very impressed with you. And Frank, I'm just going to give you a heads up. I'll probably be reaching out to you for some of my future courses and have you come in as a guest lecturer if you're interested.
Oh yeah, no, sure, no problem. I used to be adjunct faculty for University of Phoenix, so I have a little bit of experience doing many presentations. But no, thank you for the compliment. I appreciate it. It's always good to get that feedback because I can adapt my presentations to be more interesting and useful for everyone. It's depending on the audience, of course. But thank you for that compliment.
No, well done, my friend.
One thing I wanted to add what Johnny had mentioned, that a lot of times when you're doing the planning, what we've used as a tool early in the planning process, a lot of this information is available through geodata that you can get off public databases on, for example, your tax assessors have property information. You can get a lot of maps, and typically we work with GIS staff to develop a, I refer to it as a cartoon because pictures help a lot of people to understand things that you can't explain in writing or through a discussion. But if you can, like, for example, the aerial map that I provided on those land, the spatial effect of property over a project, and you have all these wells throughout that area and the underlying impact of groundwater being contaminated, that in itself helps people to kind of get the light bulb on and say, oh, okay, now I get it. Because now you can make the connection from the surface to beneath the surface. And typically, I made the argument, if you have no well or you have no basement on that property, but you have groundwater contamination, there should not be any impact to the property value. Because that is, for one, is not something that you're going to be disturbing unless you have a well on the property. Now that becomes a conduit. So now you have to look at it differently. But typically, most lenders and banks, this is a term I know that probably is not talked about a lot, but they actually red flag properties when people try to refinance. And this is especially more prevalent in lower income areas where you have groundwater contamination and a lot of things that are going on. They will red flag properties even if that property is not within the contaminated area, because most regulatory agencies will do what they call these study area maps. And they just do a broad brush of like a square mile area where the actual plume is only maybe 1/8 of a mile. But because they have to capture everything where you have the wells, now the lender or bank will look at this and say, you are within this contaminated zone, and it's going to affect your property value. And that is not true. And that's the thing that's hard to educate in the people in the banking and lending industry, in our industry. And then you get into those that are into the environmental, trying to connect all those different industries is not easy. And I think we're, as right-of-way agents, in a key position to help bring that together, because we're involved in somewhat every aspect of that.
All right, did anybody come up with a question while everybody was talking? All right, well, we would like to thank David, so we give him a big round of applause. You might be on mute, might have your camera off, but thank you very much. We'd like to thank CLS and their family of companies that I think they've got the most speakers at our virtual event. So we'd like to thank them for their employees and being a contributor to Chapter 88, along with MW Gary. And as a reminder, we also have the Crypto Summit, or Crypto Energy Summit is our lunch sponsor for the year for our in-person events. And they're having an event May 26th. We will get, once David sends me a copy of the PDF of today's presentation, I will get that out to everybody in the sign-in sheet. So if you're not connected with somebody on here, you can. And we're looking for suggestions for future presentations. So please reach out to us. And hopefully we'll see everybody soon. Thank you again, David.
Thank you, everyone. You all have a great day. Good luck with your chapter.
Thank you.
Thanks, sir.